Missouri passed a law promising to shield its residents from federal gun regulation entirely. Today, that law is dead. A revised version of it is already in legal trouble, too, and more than a dozen other states have either passed or considered nearly identical legislation, watching Missouri's legal defeat closely to figure out whether their own versions stand any better chance. If you live in one of those states, or if you've heard politicians in your own state legislature promising a law just like Missouri's, you need to understand exactly what happened here, because the full story didn't end with a single ruling. It's been unfolding for more than 4 years, through a district court, an appeals court, 2 separate trips to the Supreme Court, and a brand new version of the law the Missouri legislature passed, hoping to get it right the second time. Most coverage of this case stopped at the 8-1 Supreme Court vote in 2024, treating it as the final chapter, when in reality that vote was closer to the middle of the story than the end of it. I'm going to walk you through the complete timeline, from the law's original passage through exactly where things stand right now, and what it means for similar laws being considered or already on the books in other states. Before we get into the timeline, if you want to actually follow a legal fight like this all the way through, instead of catching one headline and assuming it's the whole story, subscribe and turn on notifications right now. This is exactly the kind of multi-year legal battle that most channels cover once and never revisit, even though the most important developments often happen well after the initial headline fades, sometimes years later, buried in a court filing or a state legislative committee vote that never gets the same attention as the original dramatic ruling. Let's get into exactly what happened year by year. Here is where this all started. In 2021, the Missouri legislature passed the Second Amendment Preservation Act, a law declaring that the state retained the power to judge for itself whether federal gun laws were constitutional, and asserting the authority to treat certain federal firearms regulations as invalid within Missouri's borders. The law prohibited state and local law enforcement from enforcing or assisting in the enforcement of those specific federal laws, and created a private right of action allowing citizens to sue any agency that violated the prohibition, with penalties reaching up to $50,000 per violation. The federal government sued almost immediately, arguing the law violated the Constitution's Supremacy Clause by actively obstructing federal law enforcement, rather than simply declining to help with it. The first segment of the timeline is the initial ruling that set everything in motion. In March of 2023, U.S. District Judge Brian Wimes ruled the law unconstitutional, finding it crossed the line from permissible non-cooperation into active, penalized obstruction of federal authority. Missouri appealed immediately and sought an emergency stay to keep the law in effect while that appeal played out, first from the 8th Circuit Court of Appeals, and when that was denied, directly from the Supreme Court itself. The second segment is the moment most people actually remember from this case, and it happened in May of 2024. The Supreme Court denied Missouri's emergency stay request by a vote of 8-1, with Justice Clarence Thomas as the lone dissenter. This vote let Judge Wimes's ruling remain in effect while the underlying appeal continued, meaning Missouri's law stayed blocked, but it was not, importantly, a final ruling on the ultimate merits of the case. It was a much narrower procedural decision about whether Missouri had shown enough likelihood of success to justify keeping a law in effect that a court had already found unconstitutional. Emergency stay applications like this one are evaluated under a specific, well-established legal test, requiring the party seeking the stay to show both a reasonable probability that the Supreme Court would eventually agree to hear the case, and a fair prospect that a majority of justices would ultimately rule in their favor on the merits, along with a showing that irreparable harm would result without the stay. 8 justices concluded Missouri hadn't cleared that combined bar, a genuinely high standard that emergency stay applicants frequently fail to meet, even in cases where the underlying legal question is closer than this one turned out to be. That distinction mattered enormously for what happened next, because the actual merits of the case still had to work their way through the full appeals process, and a denied stay application, while a significant signal, is legally distinct from a final ruling that forecloses every future argument. The third segment is what happened when that full appeals process actually concluded. In August of 2024, a 3-judge panel of the 8th Circuit Court of Appeals unanimously affirmed Judge Wimes's original ruling, agreeing that Missouri's law violated the Supremacy Clause for the same core reason the district court had identified, that it went beyond declining cooperation into actively punishing officials for choosing to cooperate voluntarily with federal agents. This was the first full merits ruling in the case, decided by 3 judges actually considering the entire legal argument rather than the emergency, expedited standard used for the earlier stay request, and it reached the same conclusion the District Court and the 8 Supreme Court justices had already signaled agreement with months earlier. The 4th segment is where Missouri's legislature refused to accept that outcome as final and tried a different approach. In January of 2025, Missouri passed a revised version of the Second Amendment Preservation Act, specifically drafted, according to the bill's sponsors, to address the constitutional problems the Eighth Circuit had identified in the original law. The revised version attempted to achieve a similar practical effect, discouraging state cooperation with certain federal firearms enforcement, while trying to avoid the specific mechanism, direct financial penalties on individual officers for voluntary cooperation, that courts had found crossed the constitutional line. This new version reflects a pattern that shows up constantly in state versus federal legal disputes, where a state legislature, having lost on a specific legal theory, doesn't abandon the underlying policy goal, but instead tries to achieve it through a differently structured law that its lawyers believe avoids the specific defect identified by the courts. The 5th segment is what happened when the original case reached the Supreme Court a second time, this time asking the justices to formally review the Eighth Circuit's merits ruling rather than just an emergency stay request. Missouri filed a petition for a writ of certiorari, docketed as case number 24-796, asking the Supreme Court to take up the case and potentially reverse the Eighth Circuit's decision. The federal government, through the Department of Justice, filed a brief opposing that petition in June of 2025. In October of 2025, the Supreme Court denied the petition, declining to hear the case at all. When the Supreme Court denies a petition for review like this, it does not mean the justices agree with the lower court's reasoning specifically, only that they chose not to take up the case, but the practical effect is the same either way. The Eighth Circuit's ruling striking down the original 2021 law became the final word on that specific version, with no further avenue for appeal remaining. The 6th segment is what this entire sequence means for the revised 2025 version of the law and for Missouri's ongoing efforts more broadly. Even with the original law's fate now completely sealed, the revised version passed in January of 2025 faces its own, separate legal questions, since it wasn't the specific law reviewed by any of the courts in this multi-year saga. Legal experts tracking the case note that the revised law will likely face its own separate constitutional challenge if state or local officials in Missouri actually attempt to enforce its penalty provisions against an officer who cooperates with federal authorities, and that any such challenge would almost certainly draw heavily on the exact reasoning the District Court, the Eighth Circuit, and by implication, the Supreme Court's stay denial had already applied to the original law. Beyond the courts, Missouri's own legislature has continued debating further gun rights legislation on this general theme. And in March of 2026, a Missouri House committee declined to advance a subsequent bill aimed at reviving similar Second Amendment protections, suggesting that even within the state legislature, there's now real uncertainty about how much further this specific legal strategy can realistically go after 4 years of consistent losses in federal court. The 7th segment is what this means for the other states considering or already pursuing similar legislation, because Missouri was never acting alone in this space, and its legal defeat carries real weight for legislatures well beyond its own borders. Multiple states have introduced or passed laws with a similar structure and similar goals, generally grouped under the broader banner of Second Amendment sanctuary or Second Amendment preservation legislation, reflecting a broader movement among some state legislatures to use state law as a shield against federal firearms regulation they consider unconstitutional. States including Idaho, Arizona, Texas, and several others have passed or seriously debated legislation using similar language and similar enforcement mechanisms, often modeled closely on Missouri's original 2021 law or drafted by the same network of state legislators and advocacy groups that helped write it. Missouri's experience through the courts, a district court loss, a unanimous appellate loss, and 2 separate unsuccessful trips to the Supreme Court, gives lawmakers and advocates in other states a real, concrete roadmap for exactly which specific mechanisms are likely to survive judicial review and which are not. States considering similar legislation now have to grapple directly with the same distinction that doomed Missouri's original law: the difference between simply declining to require cooperation with federal enforcement, which remains constitutionally protected under the anti-commandeering doctrine, and actively penalizing officials who choose to cooperate anyway, which 4 straight courts have now found crosses into unconstitutional obstruction. Some states have already begun quietly revising pending or newly introduced legislation to strip out the specific financial penalty provisions that proved fatal to Missouri's law, while others have continued advancing bills with similar language, betting that a different federal circuit, with a different panel of judges, might reach a different conclusion than the Eighth Circuit did. A genuine possibility given that federal appeals courts do sometimes split on novel constitutional questions before the Supreme Court eventually steps in to resolve the disagreement nationally. The 8th segment is the practical, on-the-ground reality for law enforcement agencies in Missouri and in any state considering similar legislation, because this multi-year legal uncertainty had real, tangible effects on how officers actually did their jobs while the law's status remained unresolved. Agencies reported genuine confusion during the period the original law was briefly in effect about whether routine participation in joint task forces handling cases that touched federal firearms statutes could expose individual officers or their departments to liability, a confusion that persisted even after courts began ruling against the law, simply because appeals were still pending and the legal landscape kept shifting. That kind of operational uncertainty, officers genuinely unsure whether ordinary cooperation with federal partners might trigger legal consequences, is exactly the kind of practical harm the federal government's original lawsuit pointed to as evidence that the law functioned as real obstruction rather than a purely symbolic statement of state policy preference. The 9th segment is how differently the two sides of this fight have characterized the entire 4-year saga, because the framing genuinely matters for understanding where this debate goes from here. Gun rights advocacy organizations and many Missouri Republican lawmakers have described the court's repeated rulings against the law as federal overreach crushing a legitimate state effort to protect its residents' constitutional rights, arguing that the federal government's aggressive litigation against Missouri sends a chilling message to any other state legislature considering similar protective measures. Gun safety organizations and the Justice Department, across different presidential administrations that have each continued pursuing this litigation, have described the same set of rulings as a straightforward and necessary application of settled constitutional principles, arguing that allowing any state to selectively nullify federal law by threatening its own officers with financial penalties would create an unworkable patchwork of enforcement across the country, undermining federal law not just on guns, but potentially on any subject where a future state legislature strongly disagreed with federal policy. Both characterizations reflect genuine, deeply held views about federalism and the proper balance between state and federal authority, and the fact that this exact litigation has now continued across changes in presidential administration suggests it reflects institutional legal positions within the Justice Department itself, rather than a position tied to any single administration's particular political priorities. Let's step back and name what this 4-year saga actually shows about how these state versus federal legal fights typically unfold in real time. A single court ruling, even a dramatic 8-1 Supreme Court vote that generated national headlines, was never actually the end of this story, and treating it as the final word missed the district court ruling that came before it, the unanimous appellate ruling that came after it, the revised law the state legislature passed in response, and the second Supreme Court petition that finally closed out the original law's fate more than a year later. That pattern, an initial dramatic ruling followed by years of continued legal maneuvering, revision, and further litigation, is far more typical of how major state versus federal constitutional disputes actually resolve than the single, clean, headline-generating ruling most people expect and remember. It's worth being honest, too, about why a story like this one is so easy to lose track of over 4 years. Each individual development, a stay denial, an appellate affirmance, a legislative rewrite, a cert denial, sounds technical and unglamoric on its own, nothing like the dramatic framing of the original 8-1 vote that made national news back in 2024. But taken together, these 4 years tell a much more complete and genuinely more useful story than any single headline could. One that shows exactly how far this specific legal strategy can go, exactly where it consistently fails, and exactly what a revised version would need to look like to have any realistic chance of surviving the same judicial scrutiny that struck down every version tried so far. That is precisely the kind of information a state legislator, a concerned resident, or an advocacy organization actually needs if they're trying to figure out what happens next, not just what already happened once, years ago, in a single dramatic vote. If you take one thing away from this breakdown, let it be this. When a state passes a law explicitly designed to test the boundaries of federal power, whether on guns, immigration, or any other contested policy area, the resulting legal fight rarely ends with the first ruling that makes headlines. Missouri's Second Amendment Preservation Act took more than 4 years, 4 separate court rulings, and a legislative rewrite to reach anything resembling a final resolution. And even now, the revised 2025 version leaves the door open for another round of litigation whenever it actually gets enforced against a specific officer. Understanding the entire arc, not just the loudest headline along the way, is what separates a genuinely informed view of how these fights actually play out from a version of the story that stopped updating the moment the first dramatic vote count made the news. If this helped you understand where this fight actually stands today, share it with someone in a state considering similar legislation, subscribe so you catch the next development in this ongoing legal battle, and I will see you in the next one.